Hi everybody, Dan Ray with my friend Brendan Beery. We're bringing you the Red Flag video series. What's the Red Flag video series? The idea is simple. We want to let you know what kind of facts you should be looking for to tip you off as to what subject you're being tested on. In other words, if you see fact A plus fact B plus fact C, that tells you that you are being tested on subject X. That's the entire idea behind the Red Flag video series. Today's video is intended to give you some ideas about the kinds of questions you might be on the lookout for if you plan to sit for either the July 2020 or the February 2021 bar exam. We want to emphasize up front that we don't have any kind of a crystal ball. We don't have any particular insight into specific things that the bar examiners are going to test on. This is based entirely on our many years in the classroom teaching constitutional law and getting a feel over that period of time for the kinds of things that bar examiners like to do. You probably have heard, if you're preparing for the bar exam, that bar examiners love to test on new stuff, and that is indeed true. So on the YouTube page where you find this video, you will also find a link to this document that has a number of Supreme Court decisions from the October 2019 term. We've summarized those decisions for you. We also have a section in that document called Current Events. The COVID-19 pandemic, we think, is a great illustration of the kind of topic that gives rise to a target-rich environment for bar examiners. They can build bar exam facts on any number of COVID-19 pandemic fact patterns that might be created. So here's what we're going to do. We're going to take a quick look at this document. We're going to talk about one of the free exercise cases that the court decided this past term, just to illustrate how the document works with the Supreme Court decisions. Then we're going to drop down and talk about the current events portion of the document. We'll talk a bit about some potential COVID-19 related problems that might pop up, and just kind of give you a feel for how you would go about spotting the facts that tell you what it is you need to be looking for. Okay? So here we go. If you haven't already, take a look at the document. You can download it again from the YouTube page. Scroll down to the free exercise cases and have a look at the Espinoza against Montana Department of Revenue case. There, the United States Supreme Court held that the Montana Constitution no aid provision, that is to say, a provision of the state constitution that barred the state from providing aid to churches or religious institutions, was invalid as applied to the facts of this case. Montana created a tax credit program, statutory tax credit program, that allowed people who made charitable contributions to organizations that funded student scholarships at Montana private schools to take a state tax credit for those charitable donations. Problem: the Montana Constitution had the no aid provision in it. So to reconcile the state constitution with the statutory tax credit program, here's what the State Department of Revenue did. The Department of Revenue created a rule that said no tax credit for any contribution that's used to fund a scholarship at a private sectarian, that is to say, religious school. There was a free exercise challenge, and the court declared that that limitation, that denial of a tax credit, violated the free exercise clause. Why? Well, as you can see, we've given you the holding of the case. We've also talked a bit about the reasoning behind the case, how the court got to that holding. But then scroll down and have a look, if you will, at the facts to watch for section. Here are the 5 key facts that we've identified from the Espinoza decision that we think should tell you this is a free exercise problem. First of all, you're looking for a government program. It's probably going to be state or local, but doesn't have to be. Could be a federal program as well. Number 2, that program provides benefits of some sort. Almost certainly monetary, but doesn't have to be. Could be in-kind benefits under a different set of circumstances. Number 3, those benefits are provided to a broad class of entities or people. Number 4, the program excludes payment or application of the benefits to or use of the benefits at, and here comes the big one, number 5, a church or religiously affiliated institution. As we will see, that fact, number 5, is the one that should tell you this is a free exercise problem, and it also points you directly to the outcome of the case. The final section that we've put here is what we call the analytical key. And that analytical key, as we just suggested, at least for now, is the fact that the Montana rule specifically targeted religious institutions and churches based on religion. When you see a law or a program that targets religion as religion, the first thing you should think of is what? Strict scrutiny. And indeed, that's where we find ourselves here. The key fact is that Montana law targeted religion as religion. Now, let's scroll down to what we call the current events portion of the document. Here's where we've put together a number of fact patterns, a number of potential fact patterns, all of which sort of revolve, if you will, around the COVID-19 pandemic. We've got one here for commerce power. We've got a dormant commerce clause discussion, a substantive due process, fundamental rights, equal protection of the law, First Amendment speech or expression. We've also got a First Amendment free exercise problem. We've done a quickie preemption problem, and we rounded out with a spending power problem. Brendan, I've been doing all the talking. Why don't you take over?
Sure. And first I'm just going to piggyback off of that presentation, and hopefully what anybody who is watching this video or any of our red flag videos will see is that there's the real value added here comes in what we professors and lawyers refer to as issue spotting. What you'll see from a number of other resources out there is here's the law, right? But what we're trying to really focus you in on is the 2 parts Dan pointed out that are absolutely key here are facts to watch for, right? This is an elemental thing, as Dan excellently put it. Fact A plus fact B plus fact C equals or means you're being tested on issue X. When it comes to the COVID material and the possible issues that are raised, which are, as you said, Dan, are many. Let me just give one example. One of the worst things, Dan, I think you and I would agree over the years, one of the worst things you can do when you are sitting for a law exam of any kind, when we're talking about constitutional law, is present a Commerce Clause analysis based on Congress's power, right, to regulate interstate commerce when you're being asked about a state, or conversely, right, to apply some kind of dormant commerce analysis when it's Congress who's doing the acting. So the way this is helpful is that we are very explicit about this. Dormant commerce, for example, the principle is that states are not supposed to be discriminating against interstate commerce. They're not to do that unless they can pass, again, the same test Dan was just talking about, strict scrutiny. But here, that's all well and good. How do you know you're being tested on dormant commerce principles? Now, to illustrate the point, if you would scroll down to the dormant commerce clause material here on this document, you'll see, again, that the key here is that we give you the facts that would trigger a certain analysis, that you know what issue you're being tested on. So here's how you know when you're being tested on dormant commerce principles or the dormant commerce clause. Now, we could have enumerated these. We could have put numbers in here, but we didn't because we were too lazy to do that. So you're going to have to do that. But we're going to talk through this so you know how to use this document, right? Break it down. The fact pattern you'd be looking for. Number one, a state or locality. That is absolutely crucial, as I mentioned earlier. This is not Congress. It is a state or a subdivision of a state, right? A state or local government. That's number one. Number two, enacts a law or an ordinance. So you break this down. If you're looking at a state, they have passed some kind of a statute or an ordinance, right, if it's a state. Number three, bars out-of-state persons or goods from entry, and as I mentioned earlier, could also bar in-staters or in-state persons or goods from going into another state. So that's obviously crucial. And all of these are, right? There has to be a state or subdivision, has to pass a statute or ordinance, and that would have to bar entry or exit from the state. Number four, there's an alternative here. Maybe the state isn't banning people from coming in or going out, but at the very least, you look at number four here, or imposes a quarantine or testing requirement upon entry. That is a fact you should absolutely be on the lookout for. And finally, number five, and this was crucial as well, in order to slow the spread of the virus or mitigate the effects of the pandemic. That is a crucial fact that you have got to be on the lookout for, because that tells you what the interest that the state will be arguing. And as you see in the analysis here, these facts that we just went through would trigger strict scrutiny. So look at, again, what this document tells you. Here are the 5 facts that tell you you're being tested on dormant commerce. Here's the analysis that you would apply.
And then we wrap up each doctrinal discussion with a brief overview of the analytical key. We tell you what the analytical key is in this dormant commerce clause analysis, and that is discrimination against interstate commerce. That's a factual inquiry. You're going to be looking for facts that tell you, again, government's trying to keep out-of-staters out or keep in-staters or in-state stuff in. That is discrimination against interstate commerce, a factual question.
Mm-hmm.
In addition, we make it clear that when you're doing a dormant commerce clause analysis, if you're in the realm of strict scrutiny, be sure to look for facts telling you that the state or locality did or did not consider less restrictive means, right? We consulted with public health experts, and they said your alternatives are A, B, C, D, and E. We rejected A, B, and C because we didn't think that they would protect public health adequately. We rejected D because we felt like it would be just as good as what we chose, but it would be a whole lot more expensive. So we threw that one out too. That's how we landed on E, which we argue is the least restrictive alternative. Be prepared to look for facts that tell you that the state considered and rejected less restrictive means. Final point with regard to the analytical key in a dormant commerce clause fact pattern. If you're not in the land of strict scrutiny, that means you're going to do pike balancing. Pike, as you should know, is almost always a winner for the state or the locality. Why? Well, you don't even get to pike balancing unless you have already concluded what? Unless you have already concluded that there is no discrimination against interstate commerce. That's the only way you get to a pike balancing test. You have examined the facts and you have said, I don't think that this law discriminates against interstate commerce. Well, what are the odds that a court's going to say this law doesn't discriminate against interstate commerce, but it does impose a clearly excessive burden on interstate commerce? Those are vanishingly small odds. So, long story short, analytical key. Pike balancing is almost certainly a winner for the state or the locality.
Okay, everybody. So just to be clear, the link to the document is in the description box below. So please click on that. We hope that this was a useful tour through this document. There's a whole lot of useful information here. We just went through a couple of examples to show you how to use this document. But again, whether it's the July 2020 bar exam or a bar exam thereafter, sooner or later, bar examiners are going to hit these topics. So again, we hope that this was helpful. If you think it was, please, you know how the routine, click like, share, subscribe, and all that good stuff. And we'll be back with many more videos about red flags in constitutional law. Right, again, factual sort of elements of fact patterns that tell you when you are being tested on what, a critical issue spotting tool. So thanks for watching, and Dan, we'll see you soon.
Good luck with the bar exam, everybody.